Hello and welcome to Study IQ English. Welcome to today's current affairs video, a short, crisp coverage of an extremely important event that has been making news since yesterday. We are talking about the Section 498A of the Indian Penal Code IPC. We also know that back in 2023, it is the same Indian Penal Code which was revised and made more modernized in the form of the Bharatiya Nyaya Sanhita by taking the old laws and compiling them into this new judicial legal code. However, since yesterday, once again, in the light of a Supreme Court's order, the Section 498A of the ex IPC and today Section 85 of the Bharatiya Nyaya Sanhita seems to be under question. Recently, the Supreme Court further endorsed a decision taken by the Allahabad High Court, which said that any victim of domestic abuse, of violence, of femicide, any such woman who experiences violence by her husband or the family of the husband, and in case she chooses to lodge a complaint against this harassment, there shall be no immediate action taken to arrest the husband or his family or to impose a fine upon them. This is subject to multiple interpretations, but as of now, it is being interpreted as a delay in justice towards women victims of violence. Now, let's understand that whether we call it violence against women or femicide, both these words include a huge umbrella of domestic violence, sexual harassment, psychological or physical assault that women in India face. And therefore, the whole purpose behind enacting Section 498A of the IPC is to provide women who are the victims of cruelty by husband some respite. The purpose is to protect women from harassment and violence within the marital household. No wonder this law is applicable only to married women, although the definition of husband could also include a live-in partner who shares any legal relationship with the victim. Now, today, the law under Section 498A has been recoded as Section 85 of the Bharatiya Nyaya Sanhita, that is the BSA. But the purpose, objective, and function of the law has not changed. It remains to be the same. Today, also, the objective is to help those women who are being forced to either pay dowry or they are being assaulted for not having been able to pay the dowry amount asked by the husband or his family. Sometimes law defines cruelty as any such physical or psychological assault on a woman that actually leads her to commit suicide. So it does include abetment to suicide. It also includes any physical injury that's serious, that can cause a danger to life itself or a danger to the limb or general health and well-being of a woman. No wonder under femicide we cover both types of molestations. Implicit, that are hidden, more psychological, and explicit, which are more physical and easy to recognize. Now, harassment also means creating unlawful demands for either money or money under dowry pretense or any valuables that a woman or her parental family is unable to furnish to the in-laws or to the husband. Now, despite the fact that Section 498 of IPC has given such a broad definition of cruelty, and it is a very important step legislated to take care of women in India, because despite the Dowry Prohibition Act of 1961, we know that the number of dowry cases in India have only been increasing. With having said that, let's understand that under Section 498A, therefore, a husband who is guilty of such harassment of the wife will be either subject to 3 years of jail and either subject to a heavy fine to be paid to the victim. But we all know that despite having such a strict code today, recently, as the Supreme Court is saying that sometimes Giving an immediate punishment to the accused may also lead to abuse of law. Supreme Court has highlighted various past cases where women have misused the power of Section 498A and falsely claimed that their family or their husband was demanding some dowry when in reality they were not even found guilty. Today, everyone is questioning this stand of the Supreme Court, that just because few women have abused the law, does it mean that we stop punishing the accused under Section 498A forever? Today, Supreme Court says let's allow a 2-month period. This is known as the cooling period, in which family courts or family committees, family welfare committees will be given the charge of handling issues like divorce, maintenance of wife, and the custody of children. Immediately, the section under IPC or Bharatiya Nyaya Sanhita will not be invoked. Only after 2 months of sufficient investigation by the Family Welfare Committee shall the IPC law or the Bharatiya Nyaya Sanhita section 85 be allowed and the accused shall be punished. So today we are asking, is that a valid jurisdiction, or does it actually take away the rights of women victims of abuse to find speedy justice? With that, another question comes up. What is the meaning of the word husband here under this IPC segment? Under this, the word husband itself has a very broad interpretation. As I said, it could be a marital partner, it could also be a partner who is not married to the woman yet, but still they are having a sufficient time of live-in relationship. So women are getting protection for both. Very interestingly, even the Domestic Violence Act in India 2005 gives protection against domestic violence to not only women under legal marriage, but also women who are the live-in partners of the perpetrator of the abuse. So let's understand that a complaint actually under section 498A is typically non-compoundable and non-bailable. Besides, it can be filed within 3 years. It has to be filed within a period of 3 years after the episode of violence or abuse has taken place. At this juncture, it's important to know the difference between non-compoundable and compoundable offense. So let's understand in legal terminology. A compoundable offense are those or includes those minor crimes, smaller crimes where victims can agree to take back or drop the charges through a compromise with the perpetrator, some dialogue, some understanding. However, talking about non-compoundable offenses, these are more serious crimes where there can be no settlement once the complaint has been lodged until a justice has been meted to the victim itself. With this, let's understand that how and when did section 498A of the IPC become the modern section 85 of Bharatiya Nyaya Sanhita? So this happened back in 2023 as the government went ahead and legislated the BNS and modernized India's age-old colonial penal laws. But as I said, despite the transformation from 498A to 85 of BNS, the purpose and the objective of the Act has not changed. Today also, both the sections, whether the old one or the modern one, they aim to protect married women against any kind of harassment, and the harassment also absolutely includes dowry demand. A lot of people are asking a question today. Has the Supreme Court, in this present verdict, which is known as the Shivangi Bansal versus Sahib Bansal case of 2025, has the Supreme Court invoked its power of Article 142 of the Indian Constitution and given this sudden extreme decision to not allow immediate punishment under BNS and to give a cooling period? Only after that should the accused be given a punishment. Why should we wait? When we ask the question that is it a delay in justice, a lot of people say that this is Supreme Court's power under Article 142, under which the Indian Constitution has given the Supreme Court of India the power to issue declarations, decrees, and orders that are necessary for ensuring complete justice if a matter is pending before the courts. Sometimes this could also include bypassing the existing laws or procedures, bypassing the existing legislative norms in India, whatever is necessary to achieve a fair outcome. A lot of people also call this judicial overreach. A lot of people also call this judicial activism. It defeats the purpose of separation of the powers between the legislature, executive, and the judiciary. But come what may, this is the decision of the Supreme Court right now. We are yet to see what developments happen in this case. Today, the Supreme Court, as it has said, that nobody will catch the accused and put them behind the bars until after the complaint a 2-month cooling off period is given, during which a family welfare committee will be looking after the entire case. So whether the case is a dowry death case or whether the case is about only demanding or psychologically harassing a woman, ideally the route should be family welfare committees, and only then, even after 2 months period, there is no decision taken. And still if the accused is found guilty, only then will section IPC or BNS be invoked. Except in the cases where, yes, there is a case of complete casualty involved, where there is a case of death, homicide, only then it should bypass the FWC route and directly go under the IPC or the Bharatiya Nyaya Sanhita. So, what exactly will be the composition of this family welfare committee, who will look into all such matters of domestic abuse before the court decides to take it in its own hands and invoke the legal segments, invoke the IPC or BNS? This committee will be composed of some retired government officials. They will include some mediators, people with a legal background, and social workers as well, typically always some women. Arrest safeguards should be, rather than immediately arresting the accused, like it has happened in some cases in the past. Now, we will allow the situation to be mediated through the FWC, that's the welfare committees, and no automatic arrest will happen under IPC or under Bharatiya Nyaya Sanhita, Section 498A or Section 85 of the Nyaya Sanhita. It should not happen for any crime which is punishable below a period of 7 years. So only in the case of very severe crimes or homicide leading to the death of the victim will IPC be invoked immediately. Otherwise, we will take the slow route, we will take the family welfare committee route. And police can investigate into the matter, but police has to wait for the family welfare court and the approval of the concerned magistrate to carry out the arrest of the victim. So this has left us in a dilemma. Whether this is justice delayed, will this translate into justice denied? Or is it valid for the court today to say that because sometimes the laws are abused by the victims, in future we will never invoke any kind of law, even if the victim has a legitimate demand? So we are yet caught up in that crossroad and waiting for the developments to happen. With this, let's end the episode with a quick question from UPSC 2019, which says, which of the following statements is or are correct regarding the Maternity Benefit Act Amendment 2017? So this is again GS paper 2. Social justice, because women are a vulnerable component of society, so we include this within social justice. Yes, of course, this is GS paper 1, social issues, where gender or women rights happens to be a very, very important issue. Okay, so this is social issue where we talk about gender based violence and the rights of women. So both GS paper 1 and 2 are involved here. Let's see the options. 1. Pregnant women are entitled for a 3 months pre-delivery and 3 months post-delivery paid leave. The second option says enterprises with creches. Creches are the daycare where working women usually keep their children so that they can work and the children will be taken care of. Many offices today provide that also, especially in the corporate segment. So enterprises with creches must allow a minimum 6 creche visit to the mother. The mother should be allowed to meet the child 6 times every day. The third option, women with 2 children should get reduced entitlements. They cannot get equal number of rights as those with 1 child. So which of the following statements is or are correct? You can pick out the valid option, and of course, do try to answer the question and do post it in the comment box below the video. We shall get back to you and we can also discuss the answer if you wish so. So with this, thank you so much for being a part of this video.